Okay, so today we're going to continue our discussion of the judicial branch and we're going to talk about the federal court system. Okay? Our desired result is to examine the federal court system and how the system of appeals works. So as we get into this, you want to keep in mind that there is the federal court system that is the national court system, and each state also has its own system of courts. Okay, and there are generally two sets of laws. So we're going to be looking at the national federal court system in this unit. So here you see the structure of the federal court system. Okay, you have the United States District Courts at the bottom. You have the United States Court of Appeals in the middle, and the highest level of the court system is the United States Supreme Court. So the first thing we want to look at when we look at the federal court system is what kind of cases a federal court can hear. And the court has to have jurisdiction. And jurisdiction is just the authority to interpret and administer the law. Okay, they have to have the authority to hear a particular case. And there are two types of federal court jurisdiction. There's federal question jurisdiction, and then there is diversity jurisdiction. And we're going to look at each of these individually. Okay. Federal question jurisdiction are cases that involve either a previously passed federal law, so some law that was passed by Congress and approved by the President, or something that involves the U.S. Constitution. Okay? And these are some examples. The one you might be most familiar with is Miranda versus Arizona. This is what gave all of us the right to hear our Miranda rights. If you are arrested, you are told you have the right to remain silent, you have the right to a lawyer. This came about because of a federal question of the U.S. Constitution. Okay, some other examples are the Bethel School District versus Frazier, and the Board of Education of Independent School District of Potawatomi County versus Earls in 2002. So federal question jurisdiction is previously passed federal laws or a question of interpretation of the Constitution. When we look at diversity jurisdiction, we're looking at potentially a federal court hearing a question of a state law. Okay? Now, they only do this if the parties are citizens of different states and the value of the case exceeds $75,000. So this is where we're talking about civil cases, one party suing another, but they have to be located in different states. If they are in the same state, it becomes a state law issue, and the federal courts would not have jurisdiction over those cases. So as we go back to our structure, we want to start with the United States District Court, which is the lowest level of the federal court system. Okay? There are 91 U.S. district courts. Okay? They are arranged geographically. The country is basically broken up. You can see here on the slide, Pennsylvania has 3 U.S. district courts, one with Philadelphia and the surrounding counties, then the middle part of the state, and then the western part of the state. That is the division of the U.S. district courts in the state of Pennsylvania. Each state even has at least one. Pennsylvania obviously has 3. These courts are not connected in any way with the state courts. Okay? And you want to keep that in mind. So the way that we address these courts, a sample would be the United States District Court of Florida for the Middle District of Florida. People who are involved in these cases. You have the plaintiff. Okay, this is the person who initiates the action. This is the person who does the initial suing. Okay, the defendant is the person being sued. So if you are suing someone in Maryland and you started the lawsuit, you would be known as the plaintiff. The person that you were suing in Maryland would be known as the defendant. In the U.S. District Court, there is one judge who presides over the case, okay? And you do have the right to have a jury hear your trial, if that's what you choose. You can also choose to just have it heard by the judge. If you choose to have it heard just by the judge and for the judge to make the decision, that is known as a bench trial. So these cases will be heard as you're usually familiar. Each side would be able to call witnesses, then the judge or either the jury would make a decision as to who is the winner of the case, and that is not necessarily where that case might end if you lose. Okay, when we go back to our structure, we're now going to talk about the U.S. Court of Appeals, and this is where the cases will go if the person who loses a trial is unhappy with the outcome. Okay, so now we'll look at how the U.S. Court of Appeals works at the federal level. Okay, the party who loses in the district court automatically has the right to an appeal. Okay, there are 13 U.S. Court of Appeals, 12 are geographic. You can see 11 of them here. There is one specialty court, which we're not going to focus too much on today. But when we talk about the courts of appeals, we call them circuit courts. Okay, so an example would be the United States Court of Appeals for the 11th Circuit. That would be, if you're looking at the map, Florida, Georgia, and Alabama. Okay, so you can see how the United States is divided up there into courts of appeals. So when we look at how the Court of Appeals works, the parties are going to consist of the appellant. That's the person who's appealing. Okay, so that's usually the person who loses the case, who's trying to get the case overturned. And that could be either the plaintiff or the defendant from the U.S. District Court. It depends on which party loses. Okay, the appealee would be the respondent of the appeal. And that would be the person who won in the lower court, who won their case in district court, who wants to keep the decision as it was. Okay? When you file to the U.S. Court of Appeals, your case is heard by a 3-judge panel, and we refer to that as the panel. They will only hear legal arguments. Okay? There will be no jury. The 3 judges will make the decision, and there is no new evidence and no witnesses presented. You basically have the lawyers for each side presenting their case, and then the judges will review everything from the lower court and from what the lawyers present, and will then make their decision. So what decisions does the Court of Appeals have the opportunity to make? They can affirm the lower court ruling, which means that they are agreeing with the U.S. District Court's decision, okay, which means the final decision stands. They can reverse the lower court's decision, which means they disagree with the decision that the U.S. District Court made, and they would change the outcome to the other side. The third option they have is to remand the case. And what this means is that they can send it back to the trial court for a further proceeding. Okay, usually they will send instructions. They will say, look, this case needs to go back to the trial court, and we need you to do this and this and this as you reconsider the case. Okay, so these are the 3 options that you will have when the U.S. Court of Appeals hears a case. And so what happens to the party that loses in the appellate court, right? Like, you've gone through 2 of the steps. What happens if you lose in the appellate court? this is when it could potentially move to the United States Supreme Court. Okay? This is not an easy task. Okay? The loser in the Court of Appeals can file what we call a petition for writ of certiorari. And basically, a writ of certiorari is asking the Supreme Court, which is the highest court in the land, to hear your case. The Supreme Court does not have to hear the case. The Supreme Court is very, very busy. They get about 8,000 requests a year for people who want them to hear the case. They get to pick which cases they want to hear, and they usually pick those that are most important, that have an impact on the largest number of people. Only about 1% of all of the writs of cert, which is what we call that, are granted by the Supreme Court and then heard. Those cases are heard then by the Supreme Court. Only about 1%, which is not very many. Okay? So if the Supreme Court agrees to hear a case, there are 9 justices, that's what we call the judges on the Supreme Court, we call them justices, who will hear the appeal. In order to win in the Supreme Court, you must get a 5-4 vote in your favor. It does not have to be unanimous. The Supreme Court very rarely makes a unanimous decision, and the Supreme Court is the final ruling. If you get your case to the Supreme Court, there is nowhere else to go. Whatever the Supreme Court decides is what will stand. Okay? And we will talk more in future lessons about how the Supreme Court works, and some of the differences between the way that the Supreme Court hears cases versus what we are used to in either a federal district court or even in a state court. Okay? So wrapping up, what we want to think about is, what is the last stop in the U.S. federal court system of appeals? This is what we should be able to answer at this time. If you have any questions, certainly feel free to reach out, and we will see you all in live class.